Good afternoon, everybody. My name is Jonathan Fox. I'm an attorney in Grapevine, Texas. And today I'm doing a presentation for Texas Legal. I almost said a Zoom presentation. I don't think this is tech. And the topic today is summer break or summer possession, dealing with family law issues, child custody. Um, so they asked me to give a little intro before we get into my presentation. And um, I'm here on behalf of Texas Legal. It's a statewide nonprofit legal benefit plan that was founded by the State Bar of Texas to better meet the legal needs of Texans. Texas Legal provides members access to over 400 network attorneys and also offers various insurance plan options. The contact information for Texas Legal will be in the comments and description box of this webinar, and please contact Texas Legal for more information on plans and benefits. So I'm one of those network attorneys. I've helped a couple of Texas Legal clients with family law issues. I also do some probate and wills. So I've been a licensed attorney since 2005. I went to law school here in Texas at the University of Houston. And I've been in the family law field since 2009. I worked for the Texas Attorney General's Child Support Division for many years. And then after that, I went into private practice. So I'm here in Grapevine. I've got a small firm, and help clients in Tarrant and Denton County, Dallas, Collin. Those are my four main counties, but I'll go out of county for other sometimes if it's the right case. And I do all kinds of family law, divorces, suits affecting the parent-child relationship, which is for people that are not married but they have children together, modifications of child custody and child support, adoptions, name changes, enforcement of family law orders. So pretty much everything that's family law, or most of it, I do. And then I also do some probate and wills, like I was telling you. So, and if you have any questions, just leave a comment and I'll try to answer them on the broadcast. So, okay. Right, we already went through this. So I'll go along to slide number 3. Yeah, today's topic is about summer, about managing the transition. It's school's over, it's summer vacation. We've got vacations going on, kids are going to camp, routines are changing, and how can we get through that successfully when you're in a co-parenting situation? So, we've got 2 homes for the kids, and kids are going back and forth, and we've been doing, I guess, the school year exchanges, and now we have to switch gears and do something different. So we will definitely talk about that. But let's talk about the law about possession and access first, just to kind of get grounded, and then we can go from there and talk more about what that means for your summer. So I think this is a really good place to start. A lot of people get hung up on the order. The order says you can do this. We have to stick to the order. Well, the truth is, when it comes to possession and access, and that's possession and access has different names. Some people call it visitation. That name is kind of gone out of style. Other states talk about parenting time. That's kind of trendy. I like it, but for some reason, I still call it possession and access. So possession and access is kind of the schedule that the kids have going between the 2 homes. The number 1 rule is that the parents can do almost whatever they want as long as they have an agreement. So, your order may say one thing, but I think it's pretty much going to be impossible to follow the order at all times. There's going to be things that come up. You're going to have to make exceptions. And so both parents should try to be flexible if they can. Um, so, and there are some people, you might have the other parent in your case just, might be difficult to work with. So you might not have a situation where you're going to be deviating from the order very much. Um, so um, a good way to think about it is that the order is just a backup for when you don't agree. But it kind of provides a framework basically that you can work off of, and it's good to have that structure when you're in a divorce or um, separation situation, just to have something to build off of, to give you structure. Um, okay, so let's back up a little bit about what is, and we're going to talk about standard possession. I mean, not everybody has a standard possession order. Some people do 50-50, and some people have like a custom order, but everybody's familiar with the standard possession order here in Texas. So and most of the orders are going to have some variation on standard possession. So I'm just going to go over what that is. It's the first, third, and fifth weekend, 6 p.m. Friday until 6 p.m. Sunday, and then every Thursday from 6 to 8 p.m. And so that's what it is during. I guess that's the non-holiday schedule. But then we've got spring break. So um, the parent with the possession schedule is going to get every other spring break, and then summer they're going to get 30 days over the summer. And if they don't designate when those 30 days are, they're going to be in July. Um, and if the father's the one with the possession schedule, he gets time on Father's Day. If it's the mother, she gets Mother's Day. The kids' birthdays, if you don't have a joint birthday party, then uh, both parents get time on that day. You alternate Thanksgiving, and then both parents get time over the Christmas and New Year's break. So, and that'll alternate. Like somebody gets the first half with Christmas, and then the other parent gets the last half with New Year's, and then it switches the next year. So, in a nutshell, that's your standard possession. You might have heard of expanded standard possession. So this expanded standard has been an option for a while. It used to be something called an election, and the thinking was, and this is not always followed, but this is what the law is. If you're good enough for standard, you're supposed to be good enough for um, expanded standard. So now, would a judge order that you get expanded standard if you took it all the way to trial? Let's say the judge is making his rendition and says you can have standard. Like, well, then you get up on your feet and like, I make my election for expanded. You you might not get it. So it doesn't quite work like that. It's not automatic to that extent, or it was not. But we'll explain the change in the law in a minute. Um, okay, so what is expanded standard? The thinking was it's closer to 50-50. So some people who wanted 50-50, they got expanded, and that took them almost to 50-50. So expanded standard is still first, third, and fifth weekends, but um, on Friday, instead of at 6 p.m., the possession starts with school release. So in this example, the parent with the possession schedule drives to school, picks up the kids or children, and then he doesn't have to return them until Monday school drop off. So he drives them back to school, he or she back to school on Monday. That's the first, third, and fifth weekend. And then you take the Thursdays, instead of 6 p.m. to 8 p.m., it's Thursday after school or Thursday school pickup until Friday school drop off. And that's every Thursday night. So when you put that Thursday together with the first, third, and fifth weekends, you're getting Thursday to Monday. So that's a pretty big block of time. So that's expanded standard possession. So there's been a movement afoot to I guess give the parent with the possession schedule more time. Some people want 50-50 to be the default. The legislature has not accepted that, but the last um, legislature here in Texas, the change that they made is that expanded standard is now the default for parents that live within 50 miles of each other. So if you live close to each other, you automatically get expanded standard unless there's a reason not to give it to you. So you would need it's going to be expanded standard um, unless the party that opposes that can come up with a reason that makes sense. Um, so and it's flexible. Let's say you live within 50 miles, you're doing the expanded, and then you move a little ways away, so you're now 60 miles away from the other parent. Well, in that case, you move back to regular standard, first, third, and fifth weekends. And if you move more than 100 miles away, then you get the long distance standard, which is probably 1 weekend a month and then 42 days over the summer instead of 30 days. So, like I said, if you don't make a designation when your 30 days over the summer are going to be, if you've got the standard, it's going to be July, but um, you know, maybe you don't want the July. Maybe you want some time in June, or you want half of June and the last half of June, the first half of July. What you want to do in that situation is make a designation in writing by April 1st to the other parent. And then that way you can get a more custom schedule for the summer. And you could get 2 periods over the summer. So you can get, let's say you wanted 2 weeks in June and 2 weeks in August. You can designate that. You just have to do it by April 1st. This is a little side note I put. As you can tell, I'm trying to be careful with my language. Some people they call the parent with the possession schedule. They used to call this person the non-custodial parent, or the NCP, and a lot of people feel that's become a derogatory term. It's kind of a little demeaning, so I don't say that. I try not to. Maybe every so often I'll say it back, but we don't say NCP. So that's in my slide. And the term parenting time is coming into fashion because possession, we think it's more, when we talk about possession, we think about things we own, objects. So when we talk about possession of children, I guess it seems a little off when the first time you've heard it. So I'm trying to use the term parenting time. It still doesn't feel right though. So I'll be using the term possession a lot. Okay, compliance issues. So what do you do if the other parent's not doing what they're supposed to? Like you get a call that says, "Don't come over and get Bobby. You know, we're doing something out of town this weekend," or Bobby's grandma wants to see him. And you're thinking, well, it's my weekend. Some people at this stage, they get that call and they don't show up, and then they complain about it later. And well, that's not accomplishing anything. You got to show up in person in order to enforce your order later. So you want to bring a certified copy of your order. And that way, if law enforcement comes, you can show that you have a right to be there and you're not trespassing. Where do you get a certified copy? You get it from the district clerk of the county that issued your order. So, what else can you do in this situation? Some people video it, and then you'll have a situation where 2 parents are videoing each other. That's not great. But I mean, sometimes you might feel that you have to do that. Another option is to bring a witness who can stay calm, that won't interfere. Don't bring somebody who's going to agitate the situation more. Don't bring current paramour. Paramour is kind of a word for boyfriend or girlfriend that gets used in family law a lot. It's kind of a funny word. I guess I like just writing it down. If violence is threatened, leave, because if somebody gets harmed, that's not going to help you see your child. And I put an example of a fatality recently that happened during a child custody exchange, which is a tragedy, happened in the parking lot of a Starbucks. So it's really terrible. A mother fatally shot a child's grandmother. So I guess you have to assume that the other person has a weapon. And some people might have seen a video of two men that were arguing and both holding firearms in Lubbock that also resulted in a fatality. So um, the best thing to do if there's any threat of violence is to leave and can figure out the situation later, because if you're harmed um, or more, then there isn't going to be any more possession. So, or if you lose your cool, um, it could result in criminal charges, and then you'd have a whole nother problem. So, um, okay, so this is for the other side of the situation. You are the parent with the right to designate the primary residence of the child. And you're thinking, wow, 30 days uh, that the children are going to be at the other parent's house. That's a long time, especially young children. That's a long time to not see them. So what can we do about that? It'd be great to call the other person and work it out and get to spend some time. But unfortunately, that we don't all have reasonable exes who are going to work with us on that. So we have to use our legal remedies. So what that person needs to do is give the other conservator written notice by April 15th, and then they can take back one weekend during that parent's month of extended summer possession. They have to do the pickup and the drop off. So they're going to go to the house, get the kids, and they're going to bring the kids back. And then also that parent can take one weekend during another part of the summer, and that way that parent can have an extended vacation with the child. The exception is you can't take Father's Day weekend. And I guess it could go the other way too, if depending on who the primary, who's got the right to take primary residence. Basically, if you're the father, you can't take Mother's Day weekend, although that doesn't fall during summer. So I guess that's not even part of the equation. But anyway, mom can't take Father's Day weekend. That's always going to be dad's. Variations on the standard possession order. So a lot of people have heard about 50-50 possession orders, and more people are doing them. But they're not always workable or in a logistical sense. If you live too far away, it's not really possible to have a 50-50 schedule because one of the parents might live too far away from the school to do it. Like I said, expanded standard is closer to 50-50. Let's see. So, and some people are like, well, I want more than expanded, but the 50-50 has already been denied. So what I've seen in mediation is that person getting a second weekday on the second or fourth week. So in addition to Thursday nights, maybe they're also getting Wednesday nights. So that's what I've seen for the parent that wants more than expanded, but isn't getting 50-50. Let's see. So, this is, we're seeing this more and more, like 50-50 during the summer. Like, so somebody's doing a standard possession order or expanded during the year, but during the summer, it's going to be alternating weeks. So why not just do 50-50 during the summer? That's coming up more and more. I think it's a good workaround, a good compromise. I mean, that way the parent got their 50-50, but on the other hand, the child's getting that more stability during the school year, being the same place for most of the weekdays when school's in session. So 50-50 is a good, during the summer can be a good solution. All right. I've got a few more slides, but I'm going to look at the comments for a second. If a child wants to live with the non-custodial parent, how likely would it be for the non-custodial parent to get majority physical custody. Would the non-custodial parent pay support? Child is over 13 years old. Okay. So once the child is 12, a custody flip, I think it's definitely more possible, because the potentially the court could interview that child to find out the child's preferences. So I guess the parent who's seeking to be primary, who's seeking the modification, would file a petition for modification and say, this child's over 12 and will testify or will, submit to an interview with the court. And there could be other grounds, though, in terms of, what if for some reason the kid's already living with that parent, like after 6 months, that parent can seek a modification. Or if there's something happening in the other home, like maybe some situation with something that could be considered abuse or neglect, or maybe little Johnny's grades went down a lot and the other parent's concerned, wants a modification. So those are also reasons for modification. But let's just talk about the one where the child's over 12, wants to live with the other parent. So eventually the court would interview that child, and the question is, if the child says, I want to live with dad, or I want to live with mom, would that be enough for the court to make the flip? No, it also has to be in the child's best interests. So just because a child says they want to live with the other parent, that's not enough, because sometimes the child might just want to live with the parent who's less of a disciplinarian. So those are things that could come up. Is it really in the child's best interest to make the move? So that the other parent could come up with evidence, reasons why it's not in the child's best interest. So you might not win even if the child's over 12. Okay, next question. If the current agreement is expanded standard, is it possible to later change it to 50-50? I think anything's possible and both sides agree. Assuming the other, I should have read the second part of the question. Assuming the other parent doesn't agree to make the change. So the question is, if you file a petition for a modification, and then you have to go through the whole litigation process, could take months, a year, would a judge eventually order the 50-50? It depends on your judge. But I think for 50-50, you need to have special conditions. The parents need to live close to each other. I feel the parents need to get along to a certain degree. Like if they're constantly bickering, undermining each other, it probably is not a good case for 50-50, because 50-50 requires a lot of collaboration. So for people that can't co-parent, 50-50 is not good for them. Now, sometimes people agree to it anyway. But would a judge just order 50-50? It depends on the judge. I think generally no, but maybe you have the case with just the right facts, and the judge would order it. And it really depends. It's judge dependent, it's fact dependent. So the question is, can you sustain the litigation to get to that point? If there is an order that parents can't leave the county or live more than 21 miles from agreed upon location, is it possible for the custodial parent to change that and move out of the area? I guess it depends how far to move out of the area. But I mean, I think once an order says, let's say, for example, Dallas and contiguous, or Dallas County and counties that touch Dallas County, let's say the order says that, then as long as one parent, or I guess the parent with the possession order, is staying there, it's pretty unlikely that the order is going to be modified. Well, let me walk that back a little bit. Let's say that other parent's not very involved. He's not doing his possession. he's not paying his support. So that makes it more likely that the modification would be granted. But if that parent's an active parent, they're doing every weekend they can, um, they're going to all the school functions, then when you move away from the area, it's basically denying the other parent possession time. And so that one's probably not going to be modified. Um, this can be a tricky situation if somebody marries like a active duty service member and they have to leave the area. I guess the maybe don't do that if you've got a possession schedule that keeps you in one place. But a lot of times people are not reading that they're getting their possession orders from the AG. They're not really paying attention, and then they end up in these situations. So, um, uh, what you might need to do in that situation is request a jury trial if you think the judge is going to rule against you and say that you have to stay. And then maybe the jury would grant the modification and allow you to leave. So that might be your only chance if you're pretty sure that the judge is going to rule against you, is to request a jury. And so, yeah, there are situations in family law where you can request a jury. Obviously, more expensive, and you know you need somebody experienced with jury trials, which don't come up in family law all the time. All right, let me continue with my slides a little bit. Exchange locations, where let's say that you're not going to the other parent's house for pickups and drop-offs. Like typically, when it's your turn to get the child, you go to that parent's house. Then when their time, um, and then when your time's over, they come to your house. Some judges flip it, so when it's the other parent's time, you bring the child to them. I think that's kind of problematic, but there was a judge in Tarrant that always did it that way. The standard AG order has the parent with the possession schedule doing the pickups and the drop-offs. So that's something to watch if you're in if the court that the 4D courts, which is courts that hear cases filed by the Attorney General. But sometimes the exchange locations are at another location because people, it's due to family violence or um, other reasons they don't want the other parent coming to their house. So McDonald's was kind of one of the most common locations, and still is. Although during the pandemic they closed down their play areas, which made it kind of hard to do transfers. But McDonald's was good because you could go in and get a receipt and prove that you were there. And so people are doing them all kinds of places. I saw a racetrack the other day. Sometimes at court, people are like, let's do it at the police station. But I'm not sure if that's such a good idea, because if something goes wrong, then you get some people coming out of the station house who are armed. And that might not be a great situation. I'm not sure that the police would be very happy that you're doing this on their property. So I would say not at the police station, but there are lots of orders that have the exchange locations at the police station. Somewhere with cameras could be good. A public place, some people do it at a park, but what if it's raining? So, it'd be good for a place that has some foot traffic, so witnesses. Co-parenting. So a lot of orders will have provisions for electronic communication, like so you can call the child or children, maybe every Wednesday, every Saturday. The parent that doesn't have the child can call the other parent and have a short conversation. So that's something people should do on their own, but obviously it's family law, so not everybody's able to work it out. So you need to have it in the order for electronic communication. This is something. There's you can probably look it up on the internet, like a bill of children's rights, and it talks about how parents should treat each other with respect. But one thing is that, maybe think about putting a picture of the other parent in the child's room. Don't badmouth the other parent. That seems to be a no-brainer, but unfortunately, it happens a lot. Kids are not chattels. What is a chattel? Chattel is like a word that we see a lot in the law. It's like something that you buy. Um, and um, I was in a case where the other attorney tried to do like an emergency order to get the kids turned over to his client, and um, this this poor guy didn't really have good grounds to do it, and the judge yelled at him and said, "Kids are not chattels." So basically, kids are people. They're independent beings. They have their own desires and feelings, and you have to treat them that way. So here's an example. Um, this was a trial that I think I was just trying to get my order signed, but I was this trial, and there was a father who had a teenage daughter, and this guy had a possession schedule, and his daughter was working at Dairy Queen, and he was very upset because he felt it was his possession time, and Dairy Queen was like stealing his time. But the young woman wanted to work at Dairy Queen, but he would call Dairy Queen and he, harass the manager or whoever answered the phone. And the judge was like, this is not good, sir. Your daughter's basically gonna hate you when she's 18 and not want to see you anymore. Like kids are not chattels. So if your kid wants to work at Dairy Queen and it's during your time, to some degree, you just have to accept it. um, Extracurricular activities. Um, basically, even if it falls during your time, your kid should do their extracurricular activities. You can't just say, well, it's my time. Junior can't go to T-ball because it's my time. No, take your child to T-ball, and you know, and if the other parent is there, it's fine. It's a public place. It'd be good for the child to see both parents at their activity, but you're going to get in trouble with the judge if you don't take your child to extracurricular activities. You could lose your possession time. Our family wizard app close are sometimes parents don't communicate very well. They're just not. They're constantly bickering, blowing up each other's phones, and the idea is with these are third-party programs. All the communication goes through an app, which the judge can see, the parties' attorneys can see, and oftentimes this will cut down on a lot of the harassing communications. Tracking devices, we're seeing this more and more. People are like, I think my phone is bugged. Um, they always seem to know where I am. That's not good if that comes up in your case that you've done something like this. So that kind of takes it to a whole nother level. Let's see. Okay. So um, summer vacation. So we're all trying to take vacations. It might not be totally possible to schedule yours during your time. I guess try to work with the other parent. If it's a great opportunity for the child, I mean, if your child has the opportunity to go to Disney World, let your child go with the other parent. Kid's going to be not very happy if they miss out on a chance to go to Disney World. Camp, kids, when you've got a baby, a toddler, a small child, it's a lot easier to kind of direct that child's activities. But when kids start to get older, preteen, teen, they've got their own stuff. We're not going to be spending as much time with them, and they're going to want to be with their friends and things. And so that means, in a way, that does mean less possession time for both parents. So camp is a great idea. If it falls during your time, it falls during your time. So co-parenting. I guess even sometimes these folks can still make us mad years after the breakup happens, and you just have to take a deep breath and just remember it's about the child. So but some people they've been divorced for long periods of time and they're still having trouble with co-parenting. So that is definitely challenging. So let's look at some more questions. All right, if the non-custodial parent is emotionally abusive of the kids that do not want contact, what can be done to legally protect the children? He refuses to go to counseling. This is a challenging situation just because it's from the perspective of a court, it's easier to prove um, physical abuse. I mean, there might be pictures of bruises and hospital records. So, but emotional abuse is abuse, and it can be proved. And it's the court's job to protect the children against abuse. Um, like the way I think about it is that the courts don't guarantee us like the best parents. It doesn't get, the court doesn't guarantee us parents of the year. The court is supposed to protect us against abusive parents or neglectful parents. So the question is, how do you prove emotional abuse? Um, so, I mean, sometimes like the facts are just so flagrant that the emotional abuse can speak for itself. Um, hmm, like for example, in the house, um, let's say a parent got remarried and all the stepkids have their own rooms, but the child of the original marriage doesn't have a room. And um, let me think of some other examples. Like uh, the there's a parent who his new spouse doesn't get along with the ex-spouse, that parent keeps on bringing the new spouse to all the possession exchanges, and that's causing discord. So those are things that when a judge hears, they're definitely going to factor into the analysis. But proving emotional abuse, you might need expert testimony, like to get a counselor to talk to the child, and then the counselor can testify. So that can be more challenging to document, but it can definitely be proven in a court, and then the court can take action and force the parent to make changes. Otherwise, that parent might lose their access. Um, so so that's definitely something that can be done. Hmm. What happens when the other parent does talk bad about the other parent during their time? The child tells you what can be done. Do the courts really do anything? I think this is challenging. Again, it's kind of a matter of the evidence because we can't bring the child to court. I mean, we could, but generally courts don't want kids to be brought up on the witness stand and testifying. It's seen as a form of child abuse to force a child to be examined and cross-examined on the stand by attorneys. So courts don't want kids brought to be brought to court. Now, some courts, especially rural counties, they're like attorneys can choose their own witnesses, and so the kid might get called to court. But in the metropolitan counties, it's highly frowned upon. It's a good way to basically destroy your case, to call the child as a witness. Um, so I think this is another case where you need some outside help. Like you need a counselor who can talk to the child, and then that way the child can relay what is said, or the counselor can be a witness on the stand. Some things that a child says, if it's an outcry of abuse or neglect, that can come in even though it's hearsay. So I'd love to talk about hearsay. Hearsay is an out of court statement offered for the truth. So, when let's say there's a witness who says, um, my cousin told me this, that's hearsay. So an attorney would object to that, and the judge would sustain the objection and not allow that testimony just because that person is out of court. You really need to bring that witness to court and have them testify on their own. But some hearsay can come in like outcry evidence of abuse and neglect. So could that come in as abuse and neglect? I think that's kind of a stretch that itself would be abuse or neglect, but maybe it could be so damaging it could rise to the level and come in as an outcry. But generally, I think you need this is where you bring in other experts. Like maybe the court would appoint an attorney ad litem who would interview the children, interview the parents, do home visits. Maybe a custody evaluation would be done. Maybe you know, there could be um, uh, therapy for the child or family counseling. So court ordered counseling. So that's what you need in this situation. Obviously, that creates problems when you've got a limited budget in a case, and that's why I like practicing in Tarrant County a lot, because they have a family court services department that offers low cost or lower cost services. So some of those resources are available for our parents, and that makes it easier for them to litigate their case. Unfortunately, when you get out into the outlying counties, they just don't have those resources. So you have to use private experts, and a custody evaluation can be $2,500 aside. Um, so it just might not be possible for a lot of people. Um, but yeah, I mean, um, co-parenting is not easy. I think you just have to keep it focused on the child, and not, because it's not about you. It's not about you winning or the other parent winning. It's about the child. So sometimes they say in family law there are no winners, but maybe everybody can be a winner. Um, so uh, yeah, so I was about to tell another story. I just have to think. I had to pause and think about it because of attorney-client confidentiality. Um, but we have to as attorneys, we have to advocate for our clients, but we also have to keep in the best interest of the child. So, well, anyway, this has been a lot of fun to talk to y'all and read your comments and answer your questions. Um, so, like I said, my name is Jonathan Fox. I am a family law attorney in Grapevine, Texas, serving the North Texas metropolitan counties, so Tarrant County, Dallas County, Denton, and Collin counties. Here's my phone number, and my email are are on the screen. And um, it's been a pleasure to talk with you. And let me know if you have any questions in the future. Thank you.